Thank you, Chairman. Under existing law, any person who retires in good standing as a law enforcement officer or investigator employed by the Department of Conservation and Natural Resources, Alcohol, Beverage Control Board, the State Forestry Commission, the Alabama Criminal Justice Information Center, the Public Service Commission, the campus police at the state institution, the Department of Public Safety, or any other state agency that requires its officers to be certified shall receive his or her badge and pistol as a part of his or her retirement. This bill would provide that any individual who retires in good standing as a law enforcement officer employed by any state, county, or municipality agency that requires its officers to be certified shall receive his or her badge and pistol as a part of his or her retirement and benefits.
My understanding you have a sub?
I do have a sub.
That's going to be offered by Representative Fiddler. Let's go ahead and get the sub before us, and then you can explain it. Then we'll have, if anybody's have any questions, we'll go from there. Go ahead.
We go over the sub, or?
Yeah, we're going to adopt the sub. What's it do? What was the changes on the sub?
The sub, in case, basically, in case the agencies can't afford the pistol, they'll give an option to buy offer to buy at a reasonable price.
I think that took care of some of the concerns and folks they had with the smaller department. So
yes, sir.
We have the sub before us. Is there any members of the committee have any questions on the sub?
Yes, sir. I'm glad you asked that question. Because I was going to ask what the cost.
Representative Jackson.
Thank you, Mr. Chairman. I was just going to ask the physical note the cost that this was going to, and you say if they couldn't have, the department couldn't afford it, then the person would purchase it themselves. So
yes, sir.
That would eliminate the physical note, I guess.
Yes, sir.
Representative Betzel.
Yeah, I just wanted a quick comment. Appreciate you working. We talked about this extensively, but yeah, just for clarification purposes, this would be a permissive act. The municipality that has the weapon, they could gift it as a part of this. This would make it illegal, or the arrangement to purchase. Also, some agencies do not issue weapons, so they wouldn't have one to provide. So
yes,
I appreciate you working with that.
Well, thank you for bringing that up. Thank you.
All right, there being no other questions on the sub, I got a motion to adopt the sub by Representative Stringer, second by Fiddler. All in favor indicate by saying aye.
Aye.
All opposed? The ayes have it. Now the bill's before us as substituted. Any questions on the bill? Not seeing none, I entertain a motion from Representative Jackson, favorable report, second by Representative Stringer. All in favor indicate by saying aye.
Aye.
All opposed? Your bill has a favorable report.
Thank you, Chairman. Thank
As
you, members.
substituted.
Thank y'all.
All right, clerk, call the next bill.
The next bill on the agenda, House Bill 264, Representative Crawford.
Representative Crawford here. Clerk, call the next bill. Huh? All right, he's tied up in another meeting. We'll move him down. Clerk, call the next bill.
Next bill on the calendar is Representative Sales, 296.
Thank you, Mr. Chairman. Thank you, committee. I bring today a bill that doesn't change the definition of resisting arrest. It simply says if a person violates this code section, they're subject to 24-hour temporary hold at that time. That's what the bill does, as a 24-hour hold period if you resist arrest.
I believe we have a sub. Representative Betzel, are you carrying the sub?
Yes, sir, I am. I introduced the sub. The sub just changes a section of title code, gets it out of Title 13, and then it's Title Code 15. Is that right? Yep.
15, 13, 191.
All right, I heard the explanation of the sub. Do you have any questions on the sub?
Yes, sir.
Representative Morris, then Representative Jackson.
Resisting arrest. And there would be a 24-hour hold, right?
That's right.
For the person that's resisting arrest. So what would happen if cameras show that the person wasn't actually resisting arrest? Would the officer be reprimanded?
It would be
for
the
that?
same if they charge them with resisting arrest, except that goes to a court date where this would go to the 24-hour hold. So I would think they have to have it because there'll be a court date at a later time. They'll be charged with resisting arrest, and that would come out at the court date. So it'd be the same with this.
Ooh, y'all just working me with these bills.
All right, Representative Jackson?
Thank you. I want to ask Representative Betso said something about code changing from 13 to what? Could you explain those difference in the codes?
Yes, sir. One's 13 and one's 15.
Yeah, I know that's the numbers. I know that.
Okay, well, I can get you
Two-
something
that's
that
two-
can explain it.
Now,
Hold
wait a
on
minute
just
now.
a
What?
second. Hold on just a second. I can get you if it's okay with the chairman. Can I have someone to address Mr. Jackson?
Who?
Jeff Bradley.
Yes, absolutely. State your name and the department you work for.
Good morning, everybody. My name is Jeff Bradley. I'm the General Counsel for the Office of Prosecution Services. If I understand the question, this bill, the amendment to it is a bonding issue. It creates a 24-hour hold before they can be released on bond. Title 13A is the criminal law code, which is where most of the criminal acts are. But all of the bonding and criminal procedures typically are in Title 15. So the idea was to leave the spirit of it in place, but move the bonding provision from Title 13A to the appropriate Title 15, which is where all the other bonding statutes are.
Thank you.
Yes, sir.
Go back to the
You got another question?
response.
Okay.
You like my answer better, didn't you?
Do you have any data as relates to a resisting? I'm trying to
sir,
figure out why are we bringing something of this nature?
It's a growing problem. Law enforcement, local law enforcement asked me to bring this. It's just getting more and more of a problem with people resisting arrest.
Is this a personal thing with the law enforcement?
No, sir.
If I refuse to answer questions, am I resisting?
No, sir. Not in my eyes. You're not.
But to some police officers, that would be resisting.
I don't.
I'm telling you because I know.
So this doesn't change the law.
I know,
It
but
just says there's a 24-hour hold. So if you charge with resisting, that's all the same.
thank you so much.
Yes, sir.
I'm going to appreciate.
All right, Representative Betso, I believe, has a substitute? Yes. Okay. All right, we have a motion to adopt the sub by Representative Betzel, second by Representative Jackson. All in favor of adopting the sub indicate by saying aye. All opposed? The ayes have it. Now the bills before us as substituted. Representative Betzel. All right, that's the, looks like we got a question. Representative, we got a second. All right, seeing no questions, we got a motion for favorable report by Representative Betzel, second by Pettis. All in favor indicate by saying aye. All opposed, the bill has got a favorable, ayes have it. The bill has a favorable report as substituted.
Thank you,
Clerk, call the
Chairman.
next bill.
Thank you,
Okay, the next bill is House Bill 304 by Representative Kiel.
Great. All right, is he not here? Representative Kiel here? Nope. He's probably another committee, so clerk, call the next bill.
House Bill 15, Representative Bolton.
Yes, sir. House Bill 15 is simply a technical change to Section 1256, the Code of Alabama. What happened when we were entertaining a bill last session, I recognized a potential gap in here in 1256 that at that time it penalizes or opens the door for penalizing an officer who issues a citation to a subject. If he then goes and negotiates out something with the court to do something like defer or something like that, it appears to give the someone the opportunity to charge that officer with contempt of court. So what many times during my career, what we did is if you issue an example, a reckless driving ticket to a teenager, you would then have the occasion sometimes to go with a parent, talk with the parent, talk with the child, and then ask that the citation either be dismissed or deferred or something else in order to keep it from going on their driver's license until you, could let them serve some time out and sort of semi-probation to where if they don't get another ticket in a certain amount of time, that would take care of it. So what I want to do is just protect the officer if he's in that situation to be able to do that, and this is all it does. It just gives the issuing officer the ability to do that, but say the mayor or someone like that cannot go do that.
All right, you heard the representative explain the bill. Is there any questions? Representative Morris?
So are you saying that if an officer had wrote a ticket and he worked it out some type of way with the parents,
Yes.
that they don't have to actually show up for court if it's already a court date?
No, that would be up to the court. What this would do is it would, the court could do that, but the officer requesting that would not be liable for any type of contempt for requesting that.
Okay.
All right, any other questions? Not seeing none, I entertain a motion for favorable report. Representative Stringer makes a motion, second by Representative Pettis. All in favor indicate by saying aye.
Aye.
All opposed? All right, ayes have it. Bill has a favorable report. Let's go ahead and, clerk, bring up House Bill 264. I see Representative Crawford is here.
Okay, 264.
Thank you, Mr. Chairman, members of the committee. Back about 3 years ago, we passed a bill that created a grant fund of $5 that was added to a boat registration. And we come to find out this is a LEA that we jeopardized over $500,000 in grants from the Coast Guard to Alabama. So what this does is rewrites it where it goes in as a fee, and then the treasurer sends the money back to the grant, and then we will be eligible for those grants from the Coast Guard. So it's sort of a fixing of how we did the first time to make sure that we don't lose the money, and that state grant for waterways and things, lakes and things are still viable. And also it has a $15 registration, a late fee if they do not register their boat annually, like most other things are.
Do you have an amendment for this bill? Or am I got the wrong bill?
No.
No, not this one. Is there any questions by any members of the committee? Not seeing none, I'll entertain a motion for approval. All right, motion by Representative Bolton, second by Representative Stringer. All in favor indicate by saying aye. All opposed? Your bill has a favorable report.
Thank you, Mr. Chairman, members.
Clerk, call the next bill.
The next bill on the agenda is House Bill 34, public hearing by Representative Bolton.
House Bill 34 is an amendment to the bill is a change to the giving false name statute at the state level. What it does, in addition to giving a false name and address, it also adds the date of birth for giving a false date of birth, because that had been a problem that some law enforcement officers had encountered, where some people were giving them a false date of birth. So they had requested this bill last year. And in addition, in working on this bill, what we did is LSA suggested that we combine two different bills we were working on. The second bill actually deals with the requirement to provide identification when an officer has reasonable suspicion to think that there's a crime afoot or similar behavior. And what we discovered is that there was no penalty in Title 15 that covered that. So what we did is we went into Title 34 and we merged these two bills. And what this does is this makes the failure to provide name, address information when the officer has reasonable suspicion to ask for it, it makes it a Class C misdemeanor. And,
I understand you have a substitute?
Yes, sir. Yes, sir. Representative Stringer has a substitute, and I'll let him explain what it is.
Okay. Representative Stringer?
Yes, sir. This is only addressing a couple of issues in this. One of them is had to go back and fix it where it was addressing an area that would be covered under Miranda. So it's going to be taking that out of the criminal section in line 66 on page 3. And it's also addressing the class misdemeanor, changing that.
All right, we got the sub before us. Everybody's got a copy. Is there any question by any members of the committee? Not seeing none, I entertain a motion to adopt the substitute. A motion to adopt substitute by Pettis, second by Fiddler. All in favor indicate by saying aye.
Aye.
All opposed? All right, now the bill's before us as substitute. It's been explained. I'm going to go ahead and start the public hearing. We have two folks that want to speak. And with that, I'm going to turn over the gavel. He's got a question after the public hearing. 3 minutes. No, we can vote on this.
All right, at this time, we'll start the public hearing. Call up Kevin Chance. He is for it. We only have two speakers, and both are in support.
Honorable members of the House Committee, my name is Kevin Chance, Chief of Police for the City of Ott. Stand before you today to discuss an issue affecting law enforcement officers across the state. The enforcement of Alabama Code 15530, which requires individuals suspected of committing a crime to provide their name and address when requested by law enforcement. This was first brought to my attention within the last year during an audit with the Alabama Municipal Insurance Corporation. I was informed during that audit that to inform my officers to be careful with 15530 because there was no criminal statute to it, and officers were getting themselves in a lawsuit or getting sued. The law serves as a fundamental tool for maintaining public safety and ensuring accountability in our communities. However, without meaningful enforcement, including criminal penalties for those who willfully refuse to comply, our officers face obstacles in carrying out their sworn duties to protect and serve. Why criminal penalties are necessary? One, ensuring officer and public safety. When an individual refuses to provide their name and address during an investigation, it creates an immediate safety risk. Officers need to know who they're dealing with, whether the individual has outstanding warrants, a history of violence, or actively fleeing justice. A refusal to identify oneself hinders the ability of law enforcement to make informed decisions, escalate encounters unnecessarily, leading to potential danger for both officers and the public. Number two, preventing obstruction of justice. In my experience as an officer, those who refuse to provide identification are doing so to evade accountability. Whether they are wanted on previous crimes or involved in a current investigation, the inability to confirm identity allows criminals to slip through the cracks. Enforcing criminal penalties deters individuals from attempting to obstruct justice by simply refusing to cooperate. Number three, enhancing the integrity of the investigation. Law enforcement officers rely on accurate and timely identification to conduct thorough investigations. The refusal to provide a name and address or even a date of birth can stall investigations, delay justice for victims, and undermine the ability of officers to gather necessary evidence. In a system that depends on truth and transparency, failing to comply with basic identification requirements should have a clear legal consequences. Number four, aligning the public expectation and lawful authority. The vast majority of law-abiding citizens understand the necessity of identifying themselves when questioned by law enforcement under reasonable suspicion. Criminal penalties are not meant to punish innocent individuals, but rather to reinforce compliance with lawful orders, ensuring that officers can perform their duties effectively. I'll give you some what ifs. What if your neighbor observes someone coming out of your bedroom window? They call the police make contact with that individual a couple blocks away. The individual refuses to give a name but claims that he lives at your house. The officer believes that an individual may have just committed a burglary but cannot make the individual identify himself, and the individual may eventually be let go.
I apologize. You get 3 minutes, and that is.
Oh, I'm sorry.
No, you're good.
5.
I should have said.
Can I just finish up?
Yes.
With the
make it quick.
bottom part. The refusal to provide a name and address during a lawful stop is not a harmless act. It's an intentional obstruction of law enforcement duties that can put officers, victims, and public at risk. Without the criminal penalties of Alabama 15530 lacks the strength it needs to serve as an effective deterrent against noncompliance. Thank you for your time. I appreciate you letting me speak. And if I got any questions, I'll be glad to answer.
Yes, sir. All right. Thank you. At this time, we'll call Sam Adams with Aaliyah. And you have 3 minutes.
I won't need them.
Yes, sir.
Chief Chance took most of my bullet points from me, so I'll just say that Aaliyah supports this bill. We appreciate Representative Bolton bringing it and working with us on it to clean up a few things before it was filed. And this will strengthen law enforcement by updating this statute, which hadn't been updated since 1966, to modernize it to make it more effective. So thank you for your consideration. Hope it gets a favorable report.
Thank you. And I think we do have one opposition that didn't realize we had a sign-in sheet. Jim Taylor. You have 3 minutes.
Thank you, members. We all back the blue, and we all support law enforcement. And so, as a former law enforcement officer, we want to give law enforcement the tools they need to do their job effectively while still balancing the rights of citizens and their constitutional rights. I don't disagree with actually many of the things that have been said, but those situations that were describe situations where law enforcement officers have a legitimate reason for requesting identification. But we know sometimes law enforcement officers routinely ask for identification. In every encounter, or it's our policy to always ID everyone we're talking to. Those policies are not constitutional. Law enforcement can ask any question of anyone. That's settled. But to demand under the threat of arrest, to demand under threat of criminal penalties requires that reasonable suspicion. I've talked with Mr. Bolton in the past about my concerns with this bill. I agree with the changes to add date of birth as a specific identifier in that case. I agree that we need if we have a statute, there should be a penalty associated with that statute. But what I asked is that before an officer makes an arrest for failure to provide that information, that they let the citizen know, this is my suspicion. I suspect that you don't live here. I suspect that you just robbed this place. I suspect that you were involved in some sort of criminal activity. To make sure that the citizen understands the difference between what they are being asked to provide and what they are being demanded to provide under threat of arrest and criminal penalty. I think that's a very common sense, minor adjustment to the bill. Give citizens a chance to invoke their rights when they have the right to do so, while still holding criminals who are, that we want to identify, that we want to put behind bars, still allowing those people to be identified. And then finally, I know we've already passed 296 out of committee, but I'll speak briefly on that. I think it's a slippery slope when we start allowing people to be held in jail prior to any conviction or
All right,
judicial.
I'm going to have to stop you there. We are only addressing House Bill 34. We're not addressing that bill.
I would say that, the combination of bills being looked at by this committee, all are interrelated, right? It's a back to blue. Many of these bills interact with each other. Tort reform affects the ability of citizens to get redressed. If that officer arrests them for failure to identify, there's basically no redress for that. If the charges for resisting, as in 296, if that charge is later dropped, they still spent the day in jail. There's really no redress for the citizens in that case. So I'd ask the committee to amend the bill in part, keep the parts with the date of birth.
I apologize, but that's your end of your 3 minutes. So that will
appreciate your time.
Yes, sir. That will conclude the public hearing part of this. And I think we've got, is it an amendment or a substitute? Okay. So we're able to vote on it now as amended.
No, we got some hands up here.
All right. Yeah, how about remain professional? You can go ahead.
When haven't I not? Because
You're called on.
Oh, okay. Because you don't like the way I address it, don't. Okay, so I had all my questions in my head right there, and then I just got a little side swipe for a moment. But when you say the Miranda rights, how do you exactly change? Because the Miranda rights are federal.
Yes.
So how do you actually make that change? Because the first thing you say in your Miranda rights is you have the right to remain silent. So
Yes.
how can we on the state level fix that on the federal level? I'm just trying to figure it out.
Yeah, on the federal level, this won't have any effect on that. What we did when we ran the original bill over in Section 15.530, there is the authority for an officer to demand an explanation of a person's actions. However, in 15.5 and in Title 15, there's no penalty clause or anything like that if they refuse. So what we did is we took the refusal to provide ID under reasonable suspicion and put it over into this bill and added a Class C misdemeanor. However, when the bill was initially filed, they had left in the section to require a person to provide an explanation of their actions, and that crosses Miranda lines. So in this sub, we took that out. So if an officer were to engage you in the field with reasonable suspicion and ask you to identify yourself, he cannot arrest you for failing to provide an explanation for why you're doing what you're doing.
Okay, so again, I'm asking, how can we, even if you taking it out and you moving something over, but you have the right to remain silent.
Yes, ma'am.
Once I get that, I don't have to answer those questions. That's like correct. That about my name. So how are we going to be able to change that? Or are we still going to end up in court behind this? Because just because we wrote it don't mean that we don't go to court for it.
I understand that, but no, the requirement to provide a person's identification doesn't cross over into the Miranda guidelines. When they start questioning them, asking them specific questions and stuff like that, it does. But simply identifying yourself is not covered by Miranda.
Okay, so and then when an officer walk up, like the gentleman was saying, everybody is, majority of the officers, I'm not going to say all, but majority.
Yeah, most
say the same thing. I want to see your ID without even when you ask the question of what violation I've committed, they be like, well, you just give me your ID. I want your ID. I want your ID. So I just think that a lot of times when we bring bills, we don't look across the aisle to see exactly what it is on the other side. We just doing things as law enforcers, like you was in law enforcement and bringing certain bills that you may feel that gonna help other law enforcement, but you're not even taking into consideration the citizens that you are approaching.
Yes, ma'am.
So it's just something that we need to think about when we start bringing these type of bills, and I'm going to let it go from there.
Thank you. Representative Jackson.
Thank you. Isn't it already a law to lie to the police?
Not specifically unless if you give them a false name or address.
Isn't that a law? To give them false information?
Yes, sir. What we're doing, we're modifying that.
It's already law. How can you modify it? It's already. But let me say this.
It's called an amendment.
See what you're doing. I've been stopped. You know, you got some hot-headed officers out there, and they demand too much to being a police officer in blue. And you're talking about protecting the blue. Now we going back to that. I saw the blue being abused, J6, and here we are going to take away my freedom of speech. I asked that officer, do I lose my right to speak because you pulled me over? When I'm asking him a question, he asking me a question. And he telling me to hush. And I said, do I use my First Amendment right?
Yeah, and that's something this law doesn't address.
But I'm asking that. But you're telling me that that I cannot remain silent.
No, what I'm saying is it really doesn't matter to the officer whether you talk or not, as long as you give them your identification.
I'm giving my name and give my ID. Then he's going to give me a lecture.
I can't speak for them.
But all of this is involved in the process. The gentleman that spoke last, he's sensible. So you're overreaching here. There's an issue between community and policing already in the state and in the nation. And what we're doing is just going to make it even worse by passing these type bills. I mean, laws are for lawbreakers. Now, that's what the law is for, those that break the law. No, I'm not a suspect unless I have done something wrong. My color shouldn't make me a suspect. And I see a lot of this happening. And so this is a bad bill, and you know what, Mr. Stringer, and I love you for your honesty, but Alabama, we need to get on board with what's equitable and what's just and what's right. And this is neither one of those. Thank you.
Yes, sir.
I might point out that at no point anywhere in this bill does it address race or ethnicity.
All right, we'll.
I just had a follow-up question as far as like I feel like it's an overreach as well. But what right does the citizen have in this whole thing? Because it seems like you're giving law enforcement a lot of autonomy, right, to kind of do whatever they want to. But if I'm a citizen and I'm not doing anything, right, whether it's you fit the description or maybe I'm just walking down the street, pretty much not doing anything, what rights do I have as a citizen under this bill?
I understand that. The only thing that this would require is that you to produce your identification, and that's it. You don't have to answer any questions or anything else. You just have to identify yourself properly, that's all.
So I guess my thing is if I'm not doing anything, right, if I feel like I'm reasonably not doing anything, why do I have to do this?
Yep. Well, because the officer is trying to answer questions in his mind, and if you're reasonably not doing anything and he gets your identification and was able to identify you and figure out that you're not doing anything, he could just send you on your way.
But don't you feel like that's a little too much power?
I don't.
All right, any other questions? Yes, sir.
Yeah, I want to chime in real quick and clear that up. This doesn't change the constitutional standard as far as what gives the law enforcement officer the ability to ask for that identification. There still must be the reasonable suspicion that the person they're contacting is committing a crime. So we're not, as part of his bill, I just want to make sure we're clear that the person is reasonably believed to be committing a crime. So we're not changing that standard. Mr. Bolton, am I wrong about that?
That's correct.
Okay.
But what is reasonable though? That's what I'm trying to figure out. Like that's kind of subjective, right?
Mm-hmm.
No, there's a legal standard that is set already in law, and I mean certainly that debate could be with a room full of attorneys, but I'm not one of them. But I simply just Representative Gray just trying to point out there's no change here to that reasonable standard. It's the same reasonable standard that exists in anything else that we're in society. We're reasonably believed to be breaking a speed limit law in which you're contacted, or reasonably believed, I mean, we could be as trivial as jaywalking and crossing the street. That reasonableness standard isn't really a question here. It's not a change as it relates to this bill.
All right, and then we're going to call on Representative Jackson. I'm going to ask everybody, let's try to be expedite if we can, because we've got several other members that's got bills waiting on us.
Thank you, Mr. Chairman. Mr. Bolton.
Yes, sir.
What brings this to your attention to introduce legislation of this?
Yes, sir. Initially, this came to me through one of the law professors at the University of Alabama School of Law that teaches in the academy, and one of the lieutenants of the local police department. And initially, this bill was just meant to add date of birth to the required information that you would ask a person for, where they had to provide you an accurate date of birth in addition to their name and their address. During the process this summer of working on this bill, Chief Chance from OP approached us about the aspect of adding the portion in about the demand for identification. And initially it started off as two different bills, but LSA elected to insert it into one continuous bill.
Okay, are these the only questions that the officer should ask?
Yes, sir. That's the only thing that's required under this law. And they were already required to give a name and address. We just added the date of birth, and we're reasonable.
Why is that so important, date of birth?
Because a lot of times what they were encountering is they were encountering people with the same names that had different dates of birth that had warrants on them. And they would use another person's date of birth in order to throw the warrant search off. That's what brought to my attention.
This is a profiling bill, and it really troubles him. And, I've been around a while, and I believe in righteousness. I believe in justice. I believe obeying the law. That's why we have law and order. But when I see law and disorder from people that saying they're law officers, supposed to be serving and protecting, that troubling to me. And you have to, I want you to spend one weekend in my skin, and you'll see where I'm coming from.
I do.
Okay, all right, thank you.
All right, at this time, we have one more question.
One more question. So if I move into a neighborhood, right, and I get up in the morning, don't know my neighbors, take off jogging around the street. I don't have my wallet, my purse, or nothing because I'm jogging in what I feel like is a safe community. So somebody live in a neighborhood, make a decision that I look like I don't belong in that community and decide to call the police. Now, that's reasonable suspicion when the police get there. Because they got a reasonable suspicion that I don't supposed to be in there. And then when they address me, I got to give them my driver license, which I don't have on me because I'm jogging. And then if they arrest me and I'm trying to tell them that I don't have it with me, but I stay around the street, even though that's violating my constitutional rights, now I got to spend 24 hours for resisting arrest. That's all I had. It's not a question. Go ahead. It's talk.
All right, at this time, we'll take recommendations for favorable report as substituted. Got a motion and a second. All in favor, state aye. Aye. Any opposed? No. Yeas, Kevin. The bill passes. All right. As substituted. All right, you can call the next bill, Ms. Teresa.
Okay, we're gonna go back to Representative Kiel's bill, House Bill 304.
Representative Kiel.
Thank you, Mr. Chairman. Thank you, committee. This bill allows that if a person is pulled over, does not have a driver's license, that their car can be impounded. The idea from this bill comes from a city ordinance in the city of Russellville that has been a long-standing ordinance that allows them to impound a vehicle if somebody does not have a driver's license. Obviously, if you do not have a driver's license, you should not be driving. And to stop somebody and then release them to drive unlicensed just should not happen. So it's happening. It's going on in Russellville now. In other cities, they have the same ordinance, and this would just allow it statewide.
All right. Any questions? All right. Representative Jackson and Representative Bolton.
Thank you. It's another overreach. They're not supposed to be driving if they don't have insurance. Am I right?
Sure.
Now, do they have not ever applied for a license, or do they never had license, or they don't have any license on them?
It could be that they never had a license. It could have been suspended. This bill, I made it if they have not had a license in 180 days. So if you just simply forget to renew your license, I mean, 6 months or 180 days is a long. Okay, 180 days.
When you're up here, you forget a lot of things. Dealing with stress and out there on the streets of Alabama. But I see where you're coming from. But still, to impound a person's vehicle, that's the only way they can get to work. Now you're creating another problem because they don't have license. Oh boy! But we want smaller government, Mr. Speaker. And I don't know how this is getting smaller, but it's keep stretching out. Thank you.
Yes, sir. Representative Bolton.
Yes, the only question I had, Representative Kiel, does this provide for, like, if I were to leave the house and not have my wallet with me and not have my license on me, but I ran out of current and everything when they ran me through the computer, simply the act of not having it on there, even though that is a violation of traffic law, that would not enable them to tow my car, would it?
It would not. It would not.
That was my concern.
No,
that's lined out down around 130, line 130 or so there.
All right. Representative Wadsworth.
I'm fine.
All right. Representative Fidler.
Just at the appropriate time, I'd like to make a favorable move to make a favorable report.
All right. Representative Pettis and Representative Jackson.
Before this bill, if you're revoked or if you've been suspended for driving under influence, the law said you shall tow the vehicle. This is taking shall out and making it a may. So this is really weakening the law, in my opinion, because you don't have a choice. If this passes, they can still let them drive off. This is making it weaker where it says beforehand, they had to tow it. They didn't have a choice unless there was if they had a family member or something like that. That was still in there. But if they're by themselves and they're revoked or they're suspended for DUI, the law said you shall tow it. This is moving it back to May.
That was not my intent. If that is the way it reads, I will be glad to.
Well, that's the way it was before.
I'll be glad to accept that amendment on the floor.
Yeah, it's been that way before. If we stopped you, we shall tow your vehicle. It wasn't up to us, so we didn't have a choice.
I'll be glad to entertain that amendment on the floor.
Okay, thank you.
Sure.
Representative Jackson.
Did you say DUI? Now, I can understand that if a man driving under the influence, you tow his vehicle. How many, I'll ask a question, how many of us in here that police officer or ex-police officers? Just two?
No, 4.
So, yeah, I see why, I see, you understand? You see where we are? Regular citizens are being bombarded by law and order, and their law. Thank you, Mr. Speaker.
Yes, sir.
Representative Kiel, is there an amendment that we have for this bill? I also want to make sure it got properly introduced before we moved on.
The only potential amendment that I'm aware of, other than Representative Pettis's, is the split of the fees. Is there another one?
I think maybe something from revenue.
That's true. Yeah, you sent me that. Okay, who's offering that?
Do we? I don't know that we. Oh, it's supposed to be tread.
We don't have it.
Okay, we don't have that amendment at this time. We can address that when it comes on the floor. We have another question. Representative Wadsworth.
Is there a limit on, like if you impound a vehicle, is there a limit on the fees that a towing company can charge for towing it?
I'm not aware of one.
There's not. And is there any type of limit on the fees that can be charged for keeping it in storage?
I'm not aware of one.
Well, in Birmingham, I mean, there's no limit on what you can charge for that. And a lot of folks get their vehicles towed, and then they get charged $300 or $400 fee just for moving it and doing that. And I think what we're doing is by doing this bill, what we're going to end up doing is we're going to put people where they're going to lose their vehicle, they're going to lose their job, and then even lose their house as a result of that. Because I've been involved where you don't put a $2 ticket in and they tow your vehicle and they charge you $400. And with all these fees, once you get in the system, you can't get it back. And is there a limit? Does this bill say that somebody has to notify the owner of the vehicle?
Well, it does have language.
After it's been towed?
I'm not sure if there's a notification mechanism in it or not.
And at the end of the day, the vehicles gets taken away and they lose their vehicle. And I just think we need to give them a fine, whatever it is. But towing the vehicle can cause folks a lot of damage, and that's what I get concerned about is putting people in the system and they never being able to get out of the system. And I think we have to be careful on doing this because.
Well, I've heard you argue that point through the years on the House floor, and I don't know if you've brought legislation before to try to fix that or not.
But I do try to prevent unnecessary fees from being imposed, and this is one that would be those unnecessary fees. Because what you're going to do is you're going to lose a car, you're going to have towing fees, and a lot of people can't come up with $500 to get their vehicle back. They could charge $1,000 for a towing, and there's nothing they can do in the state of Alabama.
Well, if there's no ramifications for not having a driver's license, why have a driver's license?
There is a ramification. That is, pay a fine, a cost, and those things, and you're already up to probably $400 just in fine and cost.
It's just unusual for a law enforcement officer to release somebody knowing that they're breaking the law. So if they're driving without a license, they give them a ticket on the side of the road, they're going to pay a fee or a fine, and then they're just going to continue on doing what they're doing.
Well, I understand that, but I
think it's unsafe for somebody to drive unlicensed.
Well, I don't think it's necessarily unsafe to drive without a license. They just don't have a license. They haven't got their license back. but I'm opposed to it because of those reasons.
Or they never had a license.
Well, I'm opposed to it as a result of this bill.
Sure.
Any other questions? Yes, ma'am. Ms. Morris.
So if an officer pull you over and they're gonna tow your vehicle, if they don't want to, can they call like a relative or somebody to come and pick the vehicle up?
Sure. I addressed that. If you look at lines, well, I don't see it now. Well, I don't see it now, but if they do not have a license, if you look on lines 130, 129 and following, if they do not have a license, then the officer will transport them to a safe place. If it is impounded.
I don't. Is that the way it's reading?
Yeah, if you look at
Jamie, it's 139 through 140.
okay, 139.
Oh, they're just saying that you're gonna take the person, but the car is still being impounded. I'm asking you, if the police officer see fits to call a family member or someone with a driver license to come and get the vehicle, like Representative Wadsworth was saying, so you won't be able to incur so many towing fees.
Well, the officer could do that because they don't have to impound the vehicle. So they could call somebody to come get the vehicle.
Okay, so I think we probably
Or they
won't
could
need
release
that.
the person. I mean, it's at their discretion.
Okay.
Representative Jackson.
Thank you. You know, there are some police officers that probably would not call. They'll call their friend that own an impound shop, got a tow company, and they're gonna, these are anomalous fees gonna come, and then you got some going on around there, because it's a lot. See, it's a lot that you don't understand going on, Mr. Kiel. You have to be out there in the real world to know what's happening. You know, we're being secluded up here in this place. We don't get out there where the people live. I do. I live out there. I represent those people. And there's some thieves out there. I mean, they're robbing you in daylight without a gun, with a pen. It's happening every day. And we are just giving them the grounds to continue to do these things that are criminal to the average citizen. I'm through.
All right, thank you, Mr. Jackson. Any other questions?
Representative Treadaway, do you have an amendment from Revenue?
It'll be right here. I kind of went by my clerk's desk and seen the video feed. And I seen where Representative Betzel was very upset with me because somebody said I was supposed to have the amendment. But I just checked and I did not get it. But they are printing it, and I'll have it here in a minute if you'll just keep going.
So we're going to hold up here for amendment? I'm messing.
Yes, sir.
I heard you the first time.
All right, any other questions? Sure.
You weren't here.
You want to?
Could we temporarily carry this over by the chair?
I'll wait.
All right, while we're waiting on that amendment, we'll go ahead and carry this one over to call of the chair for just a minute, and then we can bring up the next bill.
Thank you, sir.
Okay, the next bill is House Bill 146, Representative Pettis.
All right, Representative Pettis, explain your bill.
Under existing law, an individual charged with a crime that is committed while he or she is under 19 years of age may be tried as a youthful offender. This bill would prohibit a judge from granting youthful offender status to any individual who is 16 years of age or older and charged with the offense of murder.
All right, any questions by any members of the
Yes, sir.
committee?
Yes, sir.
Hold on.
I have an amendment.
By order here. Do we have an amendment?
I have an
All right, let's go ahead and get the amendment before us and may answer some questions, and then I'll call on the representatives that got questions.
Yeah,
Go
this
ahead and
is a-
explain your amendment.
Yes, sir. This amendment will replace line 20 on page 1 with the following: years of age or older and charged with capital murder or murder. And then it will replace, starting with line 9, replace lines 49 through 50, starting with lines 49, replace lines 49 through 50 on page 2 with the following: age or older at the time of the offense and who is charged with capital murder pursuant to section 13A-5-40 or murder pursuant to section 13A-6-2 may not be.
All right, do we have any questions on the amendment?
I'll make a motion.
Okay.
What amendment?
Wait, he just explained the amendment? So
I'll
if
make a
there's no questions on the amendment, I'll entertain a motion to adopt the amendment.
I'll
Motion by Representative Fiddler, second by Representative Stringer. All in favor by adopting the amendment indicate by saying aye.
Aye.
All opposed? All right, the bill is before us as amended. Now we got several questions, and I think it was Representative Gray, Morris, Jackson, and Fiddler.
So under this bill, say you have 4 16-year-olds in the car and one commits a crime, does this then affect all of them? Because they will be accomplices, right? If they, I mean, maybe they didn't accompany him in doing it, but it was something that someone did. They all rode together. Y'all drove off together. So will all of them get charged as adults?
That'd be up to the DA. This only applies if they are charged with the offense of murder, only murder.
Yeah, that's what I'm saying.
Yep.
One person murdered someone, but it was 4 people in the car.
Well,
but usually when that happens, they all get charged for murder, right? So, I mean, I've seen it plenty of times, right? That's what happens. So
they're charged with murder. Under this bill, they would not be eligible for youthful offender.
Even if they didn't actually commit the crime.
Well, I mean, this has only got to do if they're charged with murder. They have to be charged with offense of murder for this to kick in.
But you're not getting you can get charged even if you didn't actually do the crime. If you was just there, you can get charged. So this will also.
This just says you won't be eligible for youthful offender. Still have to go through the court. You have to be proved guilty and all that. This don't have any effect of that. This just says the hearing to grant you youthful offender or not would not be eligible for if you're charged.
They're gonna get tried as an adult, yeah.
Murder.
But because they was in the car, right?
Any offense if you're charged with murder.
All right.
Representative Morris?
Okay, so right now, do the judge have that discretion?
That's correct.
So now we're making it where the judge, we just gonna take it all out of the judge's hands about making the decisions who actually, without trying to be too offensive, went to school and made a career out of this, and we're gonna, in turns, come back, officers, and we're gonna say that the judge don't need to make that discretion based on the crime that the youthful, do they receive youthful offender or not. We just gonna take that completely away from the judge's discretion.
We'll put it up to the jury.
For a 16-year-old.
Yeah, they'll give it to the jury. To
But
decide.
you just said in your bill that they cannot be charged or granted youthful offender, so the jury don't even have that on their caseload. I mean, on the case, they cannot give them youthful offender. So you taking that away from the judicial system, and we have made it a law to say that the judge can't, and I don't even know why this is even in here and not in Judy, but we have made that decision to say that the judge can't make that discretion, even though right now they have that discretion to charge a 16-year-old as an adult or not. And what my colleague was saying, if you got 4 teenagers inside a vehicle, as the law is written now, if one of them commit murder, and if he get into it with somebody in the store and come out and he shoots somebody, and they all jump in the car, they're 16-year-olds, and they pull off, now all of them are being charged with murder, and now all of them are gonna go straight from, it would have been, the judge would have been able to use a discretion to say that these 3 right here would not be charged as an adult, but this one the other one that actually pulled the trigger would. But under this law, we're gonna say the judge don't have that discretion anymore, that they just automatic going from 16-year-old to prison with grown people, criminals who've been in the system for 30 years. Imagine a 16-year-old that's 125 pounds that don't know how to deal with conflict now being sent to a prison with grown men that's been in there for 30 years. You're talking about abuse. But again, that's on our side.
Representative Jackson.
Thank you, Mr. Chairman. I just want to reiterate that there's a separation of powers in our government. We have the judicial and the executive and the legislative branches of government. So you're really telling the judicial what they can and cannot do. You're legislating this, but this is where we are. And how many more prisons do we need to build when we open up the big monster that is already scheduled to open? It's already overcrowded, and you don't fix crime by putting people in prison. You prevent crime by educating them, and this is where we are in this hour in Alabama. We so used to locking them up, throwing the key away. No rehabilitation, I can't even pronounce it now. Rehabilitation. See, my tongue tied. But this is where we are. We don't care about people well-being anymore. And Mr. President, bring some, I hope these things don't come back to bite us as your grandchildren or your great-grandchildren. See, I don't understand why we do all this stuff in the first place. We're targeting certain people, and then what you mean for evil gonna be for somebody's good. Thank you.
Representative Fiddler.
Thank you, Chairman. The only thing I had was that I had heard from some of our judges, and they had mentioned looking at the word intentional, and I talked to Representative Pettis about that, and just thinking about the scenario that I heard from one of my colleagues back here. So if a 16-year-old was driving, he had 3 colleagues, people in his car, and with the wording of the way this is, would he be charged with murder because he wouldn't be a useful offender? He's driving, he caused the accident. Well, in that scenario, what would we have?
If you're driving and you cause an accident, you probably wouldn't be charged for murder. That would be vehicle homicide or manslaughter. This don't cover any of that. It's only if you're charged with the act of murder.
Okay. Clears that up.
All right, Representative Wadsworth.
Yeah, the only thing I would say under 13A is defines murder, and one of the provisions in there says under a person commits a crime of murder if he or she does the following: under extreme circumstances, manifests extreme indifference to human life, he or she recklessly engages in conduct which creates grave risk of death to a person other than for others. Under that circumstances, that is a 16-year-old driving excessive rate of speed that can be charged as an adult under that statute and will be classified as murder. And that's I don't have a bit of problem of charging somebody as an adult at 16 if they intentionally kill somebody or shoot somebody, but if they're driving a vehicle at excessive rate of speed at a 16-year-old, I have a problem charging them with I want them to be given an opportunity to be classified as a youthful offender if they're like just driving at excessive rate of speed, and that's what I get concerned about. But the other part of intentionally shooting somebody, I don't have a problem them being tried as adult, but that part under that under 13A 6.2 A2 under circumstance manifesting extreme indifference to human life, I do have a problem with that part. Is that something you would accept an amendment down the road on?
Well, what I talked to the DA or one of the assistant DAs, he said if you have a person that has the Glock switch and they go into a room and they just unload, you can't prove they intentionally tried to kill you, and that's where this kicks in.
But that's different because
That's what you charge them under, though.
Well, but under that circumstances, you've got a gun and they intentionally tried to do something. But what I have a problem with is somebody under that statute, under the 13A 6.2 A2, driving excessive rate of speed being charged, and they can be charged with murder under that circumstance. And I don't think I think the Glock, if they come in and they spray that, they ought to be charged with.
Well, according to the DA, it's intent. You got to be able to say he meant to kill you, or you, or you. They have to charge them under 2, and that's because we've talked about this. I met with somebody, and this is what the DA said. Under 2, if they come in with a Glock switch and they just unload it on a room, they meant to kill you, but they didn't mean to kill it, and they could not be charged under 1. They had to be charged under 2.
Let's do this. Is the member from the DA here? Is Tish here or stepped out? All right, go ahead. We'll continue.
We can talk about this on the floor. If you'll talk for Matt Simpson, he's.
Yeah, would be willing to accept something, say that they could still be classified?
If we take a vehicle, if it's like vehicle homicide, something like that, I wouldn't have a problem saying they cannot be charged if they're driving a vehicle.
Hate to bring you in here on this. This is Representative Pettis's bill, and there were some questions going back and forth here. And if you can step up, maybe they can ask you the question. Representative Wadsworth, if you'll run over that again.
Under that 13A 6.2, it says that a person be charged with murder under circumstances manifesting extreme indifference to human life. He or she recklessly engages in conduct which creates a grave risk of death to a person other than themselves.
Yes, sir.
If somebody's driving an excessive rate of speed that causes the death of somebody, could they be charged with murder under that A2 section?
Okay, so typically when I have used that section, it's been when they exhibit extreme indifference toward human life, maybe shoots into a crowd. They may not be aiming at a particular person, but they're shooting into a crowd and they're going to hit someone, so they're exhibiting that extreme indifference. If I could, Bill Lindsay, our traffic safety resource prosecutor, is who I would consider our expert on DUI and traffic offenses. If it's okay with the chairman, can he address, because it's my understanding that most of the time it takes a lot to elevate those crimes to murder, and most of those are under manslaughter, but I would not want to misspeak on that. Could I let him answer the traffic safety? Would that be okay?
Isn't that within the discretion of the DA whether to charge them or not?
It's my understanding it's based on case law, but I feel like Mr. Lindsay could give you a more accurate.
Let's go ahead and bring him up real quick.
Under that 13A 6.2 A2, under extreme circumstances, indifference to human life, can a DA charge an individual if they're driving an excessive rate of speed and causes the death of somebody under that statute, under the A2?
So if it's just speed alone, you're not going to rise to the level of manifesting extreme.
100 miles an hour.
It's not going to rise to the level. Typically, you're going to end up. It's a discretionary call by the prosecutor, by the DA.
But the DA can charge them, correct?
But the case law typically requires more than just one item. So more than just extreme speed. What else were they doing? Were they driving on the wrong side of the road? Were they impaired? Do they have a criminal history of doing these actions?
If they're driving
So
on the wrong side of the
you're going to
road-
have to have more than just
If they're
speed.
driving on the wrong side of the road and excessive rate of speed, can they, in a car and it causes death, can the DA charge them with?
I think it's going to have to be a serious level of totality of the circumstances to get to that level.
Can he be charged?
If you get to that level, yes, ultimately, if you have something where they're on the wrong side of the road, high rate of speed, they're impaired, they have prior history of DUI and reckless driving, that you could maybe make that argument that it's manifesting extreme indifference.
But is the intent of this change just mainly for block switches and things like that? Is that really the intent?
I do not know the intent of this bill, Representative Wadsworth.
Wait a minute. So you're telling me this is a high bar on an individual that's out there in a vehicle, and you know, you've got folks out here on the road killing folks. I lost a father 40 years ago to a drunk driver, and I lost a daughter, and the one that killed my daughter had a extreme past of DUIs, and so you're telling a situation that individual that was intoxicated, excessive speed, with an extreme history of arrest for DUI, could be charged with murder.
Could be charged with murder.
I have no problem with
It's
that.
an argument that we would have to make.
You would have to reach that bar.
Yes, sir.
And
Yes,
those
sir.
individuals, in my
We have to
opinion, should
prove
be
all
charged.
those facts to
Right.
rise it to the level of manifesting extreme indifference.
Representative Morris.
So you're saying that it has to the factors that play. Sorry, Treadaway, you know how I feel
Those
about
things
that.
happen.
So if you have a young man on a motorcycle, he's 16 and he's doing 150. It's late at night and no one else is on the road, so he thinks. And he runs into a car and he hit them. He don't have no criminal record of doing that, but he runs into a car, splits the car in half, and 2 people die in that car. Can he be charged with murder?
I think it would be very difficult to prove to reach that murder charge. I think you're gonna go with the manslaughter charge.
Because I've seen those cases happen where people have hit and like we got literally folks doing 40 to life for those type of incidents, and they have no record at all, but they just took it to trial because they didn't have a record, because someone told them that it had to reach that height. So they went to trial, and now they're doing 40 to life. That's why I gave that scenario. So, and then the other thing that'll take place is boating. Would that also come with boating? Like if a young man on the water, he been boating for a long time, and he 16, they having a good time. They just so happen to run into another boat. Someone dies. Would it be considered murder if the boat split in half and explosion? I just think that when we say that it has to reach a certain height, that it's there. It's like there's a possibility, and whenever you have a possibility of it happening, it can happen. So if you want to change it with the intent of the bill and saying Glock switches, then I would not just recommend vehicles, but just recommend putting Glock switches with the intent of murder.
All right, Representative Jackson.
Thank you, Mr. Chairman. I believe this bill needs to be in judicial. There's no lawyers in here right now. We got police officers and educators in here. And we work with children, we educate children, and this is law and order. And I think judicial attorneys will have more input and know what the law does and does not do. It's baffling that we have to address these type issues, and we're not the experts on these issues. One side has theirs, and here we are trying to defend the public, and we don't have the right tools to do it. Thank you, Mr. Chairman.
That's the discretion of the speaker. He's placed it in this committee. We're going to deal with it, and he can also place it in judiciary. He made it very clear that if bills needed to go through too, that he would make that call. But right now we're we're going to address the bill. Representative Gray.
I had a question still about the 4 16-year-olds, about the accomplice. And so, Randy, I was going to let Randy come up. Can Randy come up and address that?
Sure. Randy, are you a lawyer, trained lawyer? No. State your name and who you work for.
Don't know who you asked, Mr. Chairman. I was a prosecutor, or am a prosecutor, I guess, still. Have been for the last 30-something years. Tried bunches and bunches of reckless murder cases. Guys, it's fact-specific, right? And that situation, to answer Ms. Morris's question, can they be charged? Yes, they can be charged. The question is, can you sustain that charge, right, once you go to trial? It's fact-specific. Like Bill said, it can't, what you're dealing with is a difference in recklessness and negligence, right? Recklessness is a knowing that there is a substantial risk of death or serious physical injury to another person, and you say, you know what, I don't care. An example of that is you drink in excess, right? You get in the car and you know that driving home you could hit somebody head on and kill them, but you say, I don't care. I tried bunches of those cases. The Glock switch is a perfect example from Representative Pettis. Murder is either I intentionally don't like Miss Fiddler and I decide I'm going to kill her and I shoot her, or with reckless indifference, I walk into a room knowing what that Glock switch or what that pistol could do, and I pull the trigger and it goes this way and I kill 5 people over here. Okay, that's what you're talking about in those situations.
All right. Representative Gray.
I don't talk much, so just.
I got you.
So, this is what I'm trying to see, right? Like, it's okay if it's somebody 16 or 17-year-old that committed a crime. We're not against that, right? But it's about like this catch-all thing, right? It's like 2 people doing something and we're trying to catch 30, right? And that is the thing that I'm looking at, like the overreaching. Okay, you have 4 people in the car, right? 1 person did it. It wasn't a plan, right? Someone had a gun, they shot, they drove off. All of them can really be charged with murder, and all of them could basically not get you for the offender because they could all be accomplices. And I've seen it happen several times where you get one person who gets capital punishment, and then the other one, they get life without parole. And of course, they sentence them down to life and, life without parole and life. But literally all of them got charged with murder.
The question is charging versus sustaining the conviction, right? It is what was happening inside that car. Did all of these guys know that JoJo was about to shoot somebody? And were they a participant in that? Did they hand him the bullets?
Supplied
Did
a
they hand him,
gun and all those
right.
things.
All of those things play into whether or not you can sustain that. Can you make the charge? Yes, you can. But then we have the burden of proof, right? We don't, the defense counsel can sit over there and stick his tongue out and say, you've got to prove it, and we do. If we can't sustain that, then you can't sustain the conviction.
All right. All right. Seeing no more questions, I got to entertain a motion for favorable report. Representative Stringer, as amended. It has to be called before the question is called. It has to be called before the question is called. So I've got a motion for favorable report, Representative Stringer, second by Representative Betzel. All in favor indicate by saying aye. Aye. All opposed? No. The ayes have it. The bill has a favorable report.
As amended.
As amended. Thank you, Teresa. And
Okay. The next
clerk, call the next bill.
House Bill 26 by Representative Isler.
Yeah. Yes, Representative Insler, you got the floor.
Good morning, and I'm going to ask that we carry this over, and I'll just briefly explain so people understand why. The Senate passed it yesterday, a version of it. They inadvertently took out some key language from the federal statute. So we want to have some time to work with the Senate just to clear that up, make sure that we get this all right. So that's the reason I would ask us to carry it over, and we can visit it next week.
I appreciate you coming and explaining that. You've heard the representatives. House Bill 26 will be carried over at the call of the chair. I believe that's all the bills, clerk? Nope. All right, sorry, we got to go back to Representative Kiel, and we do have that amendment here.
Good.
And,
Thank you, Mr. Chairman.
Representative Stringer will go ahead and explain the amendment.
Sure.
House Bill 304 is now before us again.
All right, this is an amendment from Department of Revenue. It's going to replace line 222 through 224 on page 8 with the following. Days of the date of impoundment shall be sold or otherwise disposed of pursuant to the unclaimed and abandoned motor vehicle procedure of section 32.884 and chapter 13 of this title.
All right, we got a motion to adopt the amendment by Representative Jackson, second by Representative Fiddler. All in favor indicate by saying aye.
Aye.
All opposed. Now the bill is before us as amended. Is there any questions on the bill as amended? Not seeing none, I entertain a motion for favor report. Representative Fiddler, second by Representative Stringer. All in favor indicate by saying aye.
Aye.
All opposed. The ayes have it. Bill has a favorable report.
Thank you, Mr. Chairman.
I want to thank the State Revenue Department. They're sitting in the front row here for bringing this at the last minute, but we did get it done. Stuff that would not be allowed in judiciary.
Thank you, Mr. Chairman.
Thank you, a motion adjourned by Representative Stringer. All in favor indicate by saying aye. Aye. All opposed. We are now adjourned.
Whoa, no. I got these same folks on judiciary. It's stacked.
He's going to probably put this bill in.